Good evening and welcome to the NewsHour Agenda. I'm Madhavdas Gopalkrishnan. First up, viewers, is the agenda brief. The Vice President has sent out a strong message to the Judiciary. In fact, he has red flagged the so-called overreach of the Judiciary, saying that some judges are acting like a super parliament. He's also called for more accountability. Is this a wake-up call for the Judiciary? And viewers, second on the show will be the Congress blaming Veer Savarkar. And the question that we're asking is that to absolve Jinnah and other historical figures. The Congress has often in the past blamed Savarkar for partition, but now Pakistan's own army chief taking credit for partition. So is the Congress somewhere or the other being exposed by Pakistan? We'll be debating that tonight at 10:30 p.m. Viewers, are we witnessing an all-out war between the executive and the judiciary? I ask you this today, on a day when Vice President of India, Jagdeep Dhankhar, sent out a strong message to the Indian courts. Vice President claimed that judges these days are acting as a super parliament, whereas the reality is that the law does not apply to them. He goes on to say that Article 142 of the Constitution has become a nuclear missile of sorts, as it is available to the judiciary 24/7. He goes on to say that courts cannot issue directions to the President of India. Remember that this specific comment from the Vice President comes just days after the Supreme Court heard a petition against the Tamil Nadu governor's decision to reserve 10 bills. Not only did the Supreme Court declare the governor's actions illegal and erroneous, it actually prescribed that the President of the country should decide within 3 months on such bills, and in case of any delay, the reasons would have to be recorded and conveyed to the state. Just days after this order, the Vice President says that the Supreme Court is not really in a position to direct the President. The Vice President further slammed the Supreme Court by saying that it chose to lean on the Constitution to use its powers to direct the Union's President, but the same Supreme Court adopted a path and procedure not laid down in the Constitution when it came to the alleged case of recovery of cash from a sitting High Court judge's official bungalow. The last time the nation witnessed a judiciary versus legislature clash was over the NJAC bill in 2014, when the Parliament passed it only for it to be struck down by Supreme Court as unconstitutional. Is this now possibly the most heated up and flared up fight between the executive and the judiciary since then? Let's find out.
A situation where you direct President of India, and on what basis? The only right you have under the Constitution is to interpret the Constitution under Article 145(3). Article 142 has become a nuclear missile against democratic forces. Available to judiciary 24/7 in New Delhi, at the residence of a judge for 7 days. No one knew about it. We have to ask questions to ourselves. Is the delay explainable? Condonable? Does it not raise certain fundamental questions?
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
Let's take this across to our guest. Dr. Anand Ranganathan, author, is with us. Matthews Nedumbara is a senior lawyer joining us. Sanjay Hegde is a senior advocate joining us on the panel. Advocate Kapil Madan is a political analyst. Also with us is Tehseen Purawala, political analyst. Thank you so much, gentlemen, for joining us. Sanjay Hegde, I'm just going to quote what the Vice President has said. I'm sure you've heard the speech. He says that is this, as far as the incident that took place on the night of 14th and 15th March at the residence of a judge for 7 days, nobody knew about it. We have to ask questions to ourselves. Is the delay explainable, condonable? Does it not raise certain fundamental questions? In any ordinary situation, and ordinary situations define rule of law, things would have been different. It was only on 21st March that it was disclosed by a newspaper, and the people of the country were shocked. They were in some kind of limbo, deeply concerned and worried at this explosive, alarming expose. Your response to what's being stated here by the Vice President, Sanjay Hegde.
Well, the Vice President may have his views, but there always is an in-house procedure which is designed to insulate the judiciary from possible false complaints, revengeful complaints, and whatnot. This actually happened way back in 1990 when a policeman in Gujarat arrested a district judge and had him produced before a liquor court. Thereafter, there have been judgments which say that before starting a criminal case, the police have to take the permission of the Chief Justice. That is only one part of the Vice President's statement. The Vice President has linked it up with a lot of other things. And if you permit, just let me go to what the Vice President has been saying. It is significant that the Vice President has been saying this on a day that the Supreme Court was hearing the Waqf matter. The more I see the way this government operates, the more I am reminded of the period in the 1970s when the Indira Gandhi government demanded a committed judiciary, a judiciary made to order. Today, if you see what is being spread about in the media, in the social media, we've had comments about the court which properly place the court in Pakistan or somewhere beyond the borders of India. The courts are being accused of being unresponsive to what the public thinks. I would, with respect to the Vice President, say that in a country ruled by the rule of law, the normal rule is that be you ever so high, the law is above you.
Okay, let me bring in the other point of view now. The question though, Sanjay Hegde, it is coming on the same day. You're factually right there, but he has not referred to Waqf. To be fair to him, he's referring to a very significant case and he's talking about why is it that the rules that apply to common citizens don't apply. Dr. Ranganathan, respond to what's being stated here by Sanjay Hegde, because he is saying, and he's referring to the 1991 caveat judgment, the caveat by the 1991 judgment, I beg your pardon, which says no criminal case shall be registered under section 154 of CRPC against a judge unless the government consults the Chief Justice of India. So the process is in place for several decades now. It's not something that's happened today. Dr. Ranganathan.
Good evening, Madhav, and good evening to my fellow panelists. I think it's not about my addressing or rebutting the points made by the good lawyer, Mr. Hegde. I speak as a layman and I speak with common sense and argument that holds in, I don't want to say the court of law because I'm not so sure anymore. The point of the matter is, yes, legally, the police must take a kind of a nod from the head from the Chief Justice to start an investigation against a judge. But tell me, it is an investigation that requires forensics. Cash was found. It was burned. You require forensic, complicated investigation that cannot be carried out by judges. It has to be carried out by investigative agencies and officers. Why on earth has an FIR not been registered? That's another matter. Why on earth are no investigative officers investigating this case, experts? Or are we saying that the honorable judges are now experts in forensics? Or they are experts in crime investigation? So the Vice President is absolutely right in saying this. There has to be a common sense being applied. Nobody wants a vendetta against a judge. Yes, fine, insulate them. But don't insulate them from common sense. Don't insulate them from the law that applies to every other criminal and forensic investigation. That is what has happened. And as far as the Waqf is concerned, I don't think there is any connection. But be that as it may, I believe there should have been a connection. Because the same Supreme Court that is wanting equivalence or parity in the constitution of the Waqf board in saying, are there any non-Hindus that have been appointed on Hindu? First of all, it is factually wrong, but because yes, there have been scores of non-Hindus who have been appointed on Hindu temple boards and trusts, starting with Tirumala or Tarkeshwar, or, I mean, you have the entire communist government of Kerala, non-Hindu, sometimes you can say anti-Hindu, controlling 5 Devaswam boards. The fact of the matter is that's not the point. The point is, in the interest of equivalence and parity, would the Supreme Court have the guts to say that like the temples are under state control or their land, mosques also should come under the state control? Like the Hindu-run schools are obligated to give 25% reservation for EVS, economically weaker section pupils. The Muslim-run schools also. So there is duplicity, there is hypocrisy.
Right. Right. I'm going to come on to the first point that you made and take that question across to Kapil Madan. Kapil Madan, the moot question over here is about the kind of investigation. Does Dr. Ranganathan not have a fair point when he says that this is an investigation that requires specialists in forensics, investigators to look into it? There's an allegation of burnt notes found. We have multiple flip-flops coming from different agencies that were the first responders, the fire department. Some say we found evidence, some say we didn't find evidence. For 24 hours, 48 hours later, it is those who are the public sweepers say, yes, we swept burnt notes. Those burnt notes are found by the media, not by investigators. If there was such a plethora of evidence, why not file an FIR? Is it a system where the judiciary is ultimately shielding its own? Is a question that comes out of what the Vice President is saying.
So, Madhav, let me just address with what Mr. Dhankhar has said. I'm saying this with a sense of responsibility that he is holding one of the most highest, public constitutional office. However, his understanding of the law appears to be painfully shallow. And allow me to respond why I say so. And I'm saying this with a sense of responsibility. What Mr. Dhankhar is trying to say here is he is trying to connect and mix two independent issues. One issue is where the Honorable Supreme Court has passed a judgment insofar as what is to be done if the governor is not exercising power. That's an independent issue. The other issue is where, where this cash was allegedly found at, High Court's judge's residence. Now, but the point I am trying to make here is, while no one can dispute that there cannot be and there should not be any investigation if there is some illegality, committed by a judge. But why are you mixing these two incidents? Why was Mr. Dhankhar silent? He could have made these remarks when, this cash incident was discovered. So Mr. Dhankhar also chose this as an appropriate time when there is a judgment against the government, wherein the Honorable Supreme Court has again, highlighted how sometimes the governors are not performing their constitutional duty, and therefore that goes against the ethos or, democratic setup. The fact is, Mr. Dhankhar wants to now raise this, two issue, but because there is a judgment against the government, that's the only premise. Now, coming to what my good friend Anand is saying. Yes, there should be an investigation. We have never seen in our history Supreme Court taking such kind of a drastic measure where these kind of evidence which were available before the Honorable Supreme Court, those were made public. And I think this should be sufficient to get our public confidence.
Is that three-judge panel qualified to conduct the investigation, Kapil Madan? You not address that. You've said there should be an investigation. Yes, there is a three-judge panel. But are they equipped? Let me bring in other panelists as well. Madhavdas Gopalkrishnan is a senior lawyer and president of the National Lawyers Campaign for Judicial Transparency and Reforms. Madhavdas Gopalkrishnan, is this judges panel equipped to carry out such an investigation? Where do you stand on this?
Now, what the Vice President Dhankhar said, it's a very powerful statement. Every word, every syllable of there is absolutely correct. I completely, with all respect to my friend Sanjay Khadge, I completely disagree with him. See, the Parliament's, the job of the investigation of an offence is the job of the police. When what is the incident shows corruption, it's an incident of discloses a corrupt action on the part of the judge prima facie. And the police, the criminal law ought to have certainly been set to motion. And I filed a petition in the Supreme Court seeking a direction to the police to cause an register an FIR. And then once an FIR is registered, see, this police is also sovereign in its sphere as the Supreme Court is sovereign in its judiciary is sovereign in its sphere. So you cannot say that there's no reason to completely distrust the police. And whether it is a rape or it's a murder or a theft, all crimes are investigated by the police. The Supreme Court has absolutely no jurisdiction. What is the legal the status of this committee? A committee based on a resolution passed by the Conference of Chief Justice of India. It has no statutory force. The Supreme Court, by constituted a committee and indirectly restraining, because the 1991 judgment restrains the police from discharging its function. It is absolutely unconstitutional. Absolutely unconstitutional. And let me say one thing more. There is a very scenario now. The Parliament has been made an inferior tribunal. Every law enacted by the Parliament on matters of policy, legislative policy, which is not justiciable at all, are brought to court. For the classic example is the NJAC.
Okay.
That is a legislation on a policy and how the judges of this country has to be appointed. And the wisdom of the people of this country reflected through the.
I think you hit the nail on the head. There are many who have been talking about whether this is about bringing in, bigger reforms as far as NJAC is concerned, as far as judicial appointments is concerned. But I want to bring in Tehseen Poonawalla. You can come in on NJAC as well. Tehseen Poonawalla has been referred to by Mr. Idambara. He, of course, says that there is no legal sanctity as far as that committee is concerned. But one of the things that the Vice President also says is that Article 142 has become a nuclear missile against democratic forces. He also claims that it's functioning as a super parliament. How do you respond to that?
Absolutely correct. Is it? Can I answer?
Tehseen, question for Tehseen, please. Tehseen, please unmute yourself and speak.
Thank you, Madhav, for having me on the show. There are two aspects to this. Number one, neither the Parliament of India is supreme, neither the Supreme Court of India is supreme. What is most supreme in our country is the Constitution of India. Both the Parliament and the Supreme Court of India derive their powers from the Constitution of India. That's the first part of it. Now, I do agree in principle to Article 142 and its misuse. For example, in the BCCI case, absolute misuse. Justice Lodha was sitting there deciding who is there, and some random cricketers, ex-cricketers, somebody's fan, Sunil Gavaskar ji, etc., Vinod Rai ji were put into the BCCI. And sometimes it's being well used by the Supreme Court. Now, this arbitrariness should go. The problem out here is there are twofold out here. One, why are these matters going to Supreme Court? So as somebody who will tomorrow be involved in government, I'm very uncomfortable with Supreme Court telling my assembly, if I'm the speaker of an assembly, how I should conduct my assembly. Because Matthews is right. My assembly is sovereign. The Supreme Court is telling the speaker how an assembly should be run. Very wrong. Can the speaker tell the Supreme Court on how many days of judgment should be taken? Very uncomfortable with that. I'm very uncomfortable with what's happened, for example, in Pakistan, where the Supreme Court had summoned the Prime Minister, Nawaz Sharif. That can tomorrow happen in our country. But on the other side, look at what the assemblies is doing. They sit on decisions for months on end. Yadurappa ji got in the police in the assembly. The police commissioner was inside the assembly during the first Operation Lotus. So then Supreme Court takes the view that, listen, ultimately the basic structure has to be protected. Speakers don't take decisions for months on end. Now, in both these cases, both these organs of our democracy are clashing. There has to be a Lakshman Rekha, a very thick Lakshman Rekha, not a thin Lakshman Rekha. While I am very uncomfortable with Supreme Court telling a sovereign assembly or sovereign parliament how it should be run, on the other hand, parliaments and assemblies sitting on it. For example, again, the farm laws. Just allow me 30 seconds of nuance on this. Farm laws were passed by a voice vote. Now, matter went to Supreme Court. Supreme Court can strike it down, saying the farm laws are ultra vires of the Constitution. Say it's absolutely illegal. You guys protest. What does Supreme Court do? It puts the farm laws in abeyance. How is it in abeyance? It stays the farm laws. What is staying the farm law? So I don't understand. Even in my case for the Kashmir issue, I think in the Kashmir issue, the next case was the late Sitaram Yechury's case. Supreme Court is telling Sitaram Yechury ji, you can go to Kashmir, no doubt about it, but you can't do politics. No, he's a politician. He's going to do politics. Similarly, government is lying to Supreme Court. Everything is normal. Both organs need to take a step back, have a very thick Lakshman Rekha.
All right, both
trespassing.
All right, both pillars of democracy, both need to take a step back. There are problems in both areas, whether we're talking about our legislature or whether we're talking about our judiciary. Is that a balanced stand that has been taken, Dr. Raghunathan, and do you agree with that?
Yes. No, just 5 seconds, because, the debate started with Mr. Hegde saying that what is happening right now is what the dictator Indira Gandhi did. She wanted a pliant judiciary. Well, it's contradictory, because if Modi wanted a pliant judiciary, then he would not have overturned the NGAC decision of the parliament that was overturned by the Supreme Court.
You want to respond to that, Sanjay Hegde?
You want me to respond?
Well, because if a bad law is struck down, you can't reenact it. You have to take care of what has been pointed out to be bad. Now, constitutional amendment was made. The constitutional amendment was struck down, saying that it violates the basic structure. Now, as long as the basic structure doctrine holds in this country, and some of the judges or the past judges have said that if there was no basic structure, then this country could possibly not be held together. It will ultimately come down to the judges saying that, look, Parliament, you have the power to make laws, you have the power to change the constitution, but you cannot change the constitution's basic structure. And we say that this law or this constitutional amendment violates it. Specifically, when it comes to judicial review, that has been held to be part of the basic structure of the constitution.
All right.
Parliament cannot just take away judicial review. If you imagine that you're going to have a tame judiciary, which will ritually rubber stamp anything that Parliament does, then you do not have a judiciary which acts in accordance with the constitutional mandate.
Okay, it's part of the constitutional mandate and the independence of the judiciary. Respond to that, Madhavdas Gopalkrishnan. Judicial review is very much part of the constitutional mandate, says Sanjay Hegde. Quick response.
That is, if you can give me 1 minute, I will tell you how laughable the concept of basic structure theory. It's a much hailed one, but actually it is against the basic jurisprudence. Who can go to a court? A person aggrieved. If my fundamental rights are infringed, I can go to the Supreme Court without recourse to any other court. So before the Keshavananda Bharati's case, people used to go to the court saying that my fundamental rights are infringed. After Keshavananda Bharati's case, the court asked, why are you here? Then they said, none of my fundamental rights are infringed. The basic structure is infringed. It is absurd, absolutely laughable proposition.
All right. We'll have to leave it there. Certainly, the Vice President has sparked off a huge debate, at least as far as legal circles are concerned. What's going to be the fallout of this? Will there be any impact? Is there the questions, of course, that are coming in from some of the panels on political timing of this, but nevertheless, certainly a lot of food for thought. Dr. Anand Raghunathan stays with us, as does Tehseen Poonawalla for debate number 2. I'd like to thank Matthews Nedubara, Sanjay Hegde, and Advocate Kapil Madan for joining us on this debate.